Case People versus Winslow Teague. All three of his cases.
Assistant Public Defender Shannon Carey.
Oh.
On behalf of Mr. Winslow Teague on the 1406 and the 5249 matters.
I apologize for a second. The first case I called for you, you actually were here.
Got it.
Yeah, it's like a blind squirrel finding a nut. It just happens. All right. Mr. Owen.
And good morning again, Judge. I am here as well. On behalf of Mr. Teague in case 210501.
Judge, we just have some documents for Mr. Teague.
10501.
Did I?
I don't.
210. Oh, did I read the wrong?
1329.
I read
That's
the wrong
okay.
number. My
Okay.
apologies, Your Honor.
No, that's fine. All right. And your name, sir?
Winslow Teague.
All right. What are we doing on this case?
Your Honor, I believe, at least in my matter, we've reached a plea agreement.
There's also an
Today
agreement
is
of
the
mine. The
16th.
court is not in receipt of it. They are guilty pleas. We just needed him to sign it, Judge.
That's mine.
Oh, no, that's not. That's okay. Yeah, all day. Five, 4, 9. 5249. That's on this one.
Oh, no. That's an old court date.
I have plea agreement forms which have been submitted. The starting in case 5249 indicates that the defendant will be pleading to the charge of use of a controlled substance, a 1-year offense. That upon a successful plea to that, count 1 would be dismissed. Defendant agrees to complete residential substance abuse treatment. And then there's an indication that the prosecutor will recommend sentence under 7411 with condition that he successfully complete treatment. That's on that case. On the case 13 ending in 1329, that the defendant is going to plead to attempted unlawful use of a motor vehicle, making it a 1-year offense. And upon that's a count 2, his count 1 would then be dismissed, and defendant in that case is agreeing to complete residential treatment. In the last matter ending in 1406, the court's plea agreement indicates that the defendant is pleading guilty to the charge of larceny 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and defendant in that case is agreeing to complete residential substance abuse treatment. That's the court's full understanding of the agreement. Is that correct, counsel?
That is correct, Your Honor.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Winslow Teague.
All right. Sir, it is this court's understanding that you are going to be pleading to 3 misdemeanor charges. Is that correct? All right. First case, the case ending in 5249, this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Understand that? You also understand on that charge, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, sir.
And on all of the forms, I will be checking the sentencing judge waiver unless there's a.
No, Your Honor.
In the matter ending in 1329, you are also going to, court's understanding, be pleading to attempted unlawful use of a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $750 fine plus court cost. Do you understand that?
Sure.
You understand also in that case that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. And then also in the case ending in 1406, that you would be pleading guilty to the charge of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? You also understand in that case that Judge Washington would be your sentencing judge.
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of attempted unlawful use of a motor vehicle, how do you plead?
Guilty.
To the charge of larceny 200 to 1,000, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
Yes? You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes, sir.
Anybody threaten you or coerce you?
Yes, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of these offenses?
Yes, sir.
All right, starting with 5249. On the date of October 8th, 2025, at the location of South Industrial Highway, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamines in your possession?
Yes.
Had you used them?
Yes.
Did you know what you were using was methamphetamine?
Yes.
Going to the next case ending in 1329. On the date of December 13th, 2023, at the location of 1274 North Prospect in Ypsilanti Township, Washtenaw County, State of Michigan, what'd you do with reference to a 2011 Ford Focus belonging to John Redente?
Your Honor, could I voir dire?
Yes, go ahead, please.
Mr. Teague, on that date with that vehicle, did you originally rent that vehicle?
Yes, sir.
And did you return it when you were supposed to?
No, sir.
And you knew when you were supposed to return it, correct? And you just did not,
Correct.
and did not have the intent to return it.
No, I was going to return it. I just.
Not at the,
Not
not
at
at the
that
appropriate time.
Right. Yes.
All right. And in the last case, ending in 1406, on the date of August 3rd, 2025.
I'm sorry, star six.
location-
Please hit star six, unmute me.
Now they're unmuted. They're fighting
Erwin
with you.
reporting to Virginia.
Who's that?
I don't know what's a dial-in runner.
It is? The case ending in 1406, on the date of August 3rd, 2025, 3040 Washtenaw Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do at the Jets Pizza store that makes you think that you're guilty?
I saw the iPhone.
You stole an iPhone that was just there?
Yeah, it was on the counter.
All right.
I knew it wasn't mine. I just took
You
it.
knew it wasn't yours, didn't belong to you?
Correct.
All right, you had no property interest in it at all, correct?
Correct.
And was the value of the iPhone in excess of $200? Yes. All right. Sir, I do have to advise you with reference to all of these cases that if I accept your plea, from the time that I accept your plea to the time that you are sentenced, if you commit misconduct as defined under the Michigan court rules, the judges in those cases would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
You understand also you would not be entitled to withdraw your plea.
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to the pleas in this case, these cases?
None that I'm aware of.
No, Your Honor.
None of your honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's pleas in these cases?
I'm satisfied, Your Honor.
Yes, Your Honor.
And defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty in all three cases to the use of a controlled substance, attempted unlawful use of a motor vehicle, and the larceny 200 to 1,000. Starting with the Ann Arbor case, pre-sentence investigation and report is ordered. At 15th District Court probation. Sentencing in that matter will occur November 7th, 2025, 8:30 before Judge Perry. And matter found will continue. In the case ending in 1329, unlawful use. Actually, I can do both of these at the same time. Having accepted the pleas to count 2 and dismissing count 1, pre-sentence investigation and report is ordered in both of those cases. Sentencing in those matters will be
November 13th at 10 a.m.
November 13th, 10 a.m. before Judge Washington. And in those matters, bond will continue.
Not in bond, your honor.
I knew you were going to say something. Go ahead.
We just wanted to remind the court that the agreement is that my client be released to residential inpatient treatment.
I don't have a problem with that. Are there orders that?
I will send the order over right now, Judge. And that will encompass all 3 cases.
Well, he's
So,
already got a PR
Yeah,
bond in mind.
he's got a PR bond in Mr. Elman's case, so just my 2 cases.
In your 2 cases, then that's fine. If I get that, they're signed off on, then I'll sign it, release them to inpatient.